Welcome to this presentation on the EU Timber Regulation. The purpose of this presentation is to look at the EU Timber Regulation in more detail, following the introduction that was given as part of the presentation on the EU FLEGT Action Plan. This presentation is part of a series developed by NEPCon under a project called Increasing Capacity of CSOs and SMEs to Implement FLEGT Requirements. The project aims at increasing capacity of civil society organizations and small to medium-sized enterprises to implement FLEGT requirements. The project is funded by the European Union and is implemented by NEPCon and SFMI, the Sustainable Forest Management Institute in Viet Nam. This presentation will cover basic introductory information on the EU Timber Regulation, before focusing on the actors involved in the implementation of the regulation and the legal obligations of these actors. We will then look at what is defined as legal and illegal timber under the regulation, see what products it applies to, and discuss how it is enforced. We will then return to the obligations of what are termed operators and examine the most important requirements of the regulation in more detail. The presentation will conclude with a short discussion of the impact of the EU Timber Regulation on producer countries and a listing of the official documents and information relating to the regulation. The regulation that we are talking about is officially titled Regulation number 995/2010 of the European Parliament and of the Council of 20 October 2010, laying down the obligations of operators who place timber and timber products on the market. Commonly, it's just referred to as the EU Timber Regulation or EUTR. The EUTR was created as part of the EU FLEGT Action Plan, the European Union's commitment to addressing illegal logging. The EU FLEGT Action Plan was approved in 2003 and sets out measures to achieve its three main aims of preventing the import of illegal timber to the European Union, improving the supply of legal timber, and increasing the demand for timber from responsibly managed forests. One component of the action plan is the use of existing or new legislation to support it, and this is where the EUTR has come in. The EU Timber Regulation aims to reduce illegal logging by ensuring that no illegal timber or timber products can be sold in the European Union. Furthermore, it aims at developing responsible trade practices and at educating suppliers and consumers on the EU market to take measures to ensure that timber has been extracted in compliance with the national legislation in the place of harvest. It is intended that this will help reduce deforestation worldwide and diminish its significant negative economic, environmental, and social impacts. Key to the regulation is that it prohibits illegally harvested timber from being placed on the EU market. Prior to the enactment of the regulation, it was not illegal to place illegally harvested timber on the EU market. It was soon after the EU FLEGT Action Plan was adopted in 2003 that it was recognized that there was a need for additional legislative options to achieve the aims of the Action Plan. It took some time for a draft to be developed, and it was in 2008 that one was proposed by the European Commission. This was revised, and eventually, on 20th of October 2010, the European Parliament voted to outlaw illegal timber and timber products from the EU market and passed the regulation. On the 3rd of March 2013, the regulation entered into force. It does not apply retroactively, so it only applies to timber products placed on the EU market after this date. Moving on to the requirements and scope of the regulation, the EUTR contains three key obligations. Firstly, it prohibits companies in Europe from placing illegally harvested timber and products derived from illegal timber on the EU market. Secondly, It requires companies placing timber on the EU market, which are referred to as operators, to conduct due diligence on the timber they are sourcing. This requires operators to obtain information on the products they are importing and to take steps to assess and minimize the risk of those products being illegal. Thirdly, the regulation also contains requirements for traders that buy or sell timber already on the EU market to keep records of who they buy timber from and who they sell it to. Importantly, only products that carry a FLEGT license or a valid CITES permit or certificate automatically comply with the EUTR. When a product carries either of these licenses or permits or certificates, operators do not need to conduct due diligence for the risk that the product is illegal. Continuing on, the EU timber regulation is legally binding on all 28 EU member states. It applies to timber products harvested or produced within the EU, as well as products produced in other countries and then imported to the EU. In terms of the types of products, it applies to a wide range of timber and timber products, including solid wood products, flooring, plywood, and pulp and paper. Not included are recycled products, as well as printed papers such as books, magazines, and newspapers. The actual product scope can be amended if necessary, meaning it could change in the future. We will look at the scope of products in more detail shortly. Before we get to that, however, we will examine who is involved in the implementation and enforcement of the regulation. Most broadly, there are four main players. Firstly, we have the European Commission and the member states of the European Union. The separate countries must all designate at least one competent authority, which is responsible for enforcing the regulation nationally. Then there are, of course, the companies that the regulation applies to. These are the companies that buy and sell wood products within the EU, and they are split according to whether they place timber on the EU market for the first time or trade timber already on the EU market. Finally, we have monitoring organizations, which have a special role in assisting companies comply with the regulation. To provide more clarity on what placing on the market means and what operators and traders are, we will use this diagram. Placing material on the EU market means that the specific timber product must be physically present in the EU, either because it was harvested in an EU country or because it was imported to the EU from another country. EU operators are those who place timber products on the market for the first time. Traders, on the other hand, are entities that buy or sell timber and timber products already on the market. Traders will either buy timber from operators or from other traders. To be more specific about what placing on the market is and who the operator is, with timber produced outside of the EU, then imported to the EU, the operator is the entity acting as the importer when the timber is cleared by EU customs authorities for free circulation. It is important to note that the definition of operator is independent of the ownership of the product or other contractual arrangements. With respect to timber harvested inside the EU, the operator is the entity that distributes or uses the timber once it has been harvested. In going through the obligations of the different actors, we'll first look at the operators. Given that operators are organizations that place timber on the EU market, they are subject to the main requirement of the EUTR, that placing illegally harvested timber on the EU market is prohibited. Operators are obliged to exercise due diligence through a system and procedures which must be maintained and regularly updated. The purpose of this due diligence system is to minimize the risk of illegally harvested timber and timber products, and the system itself must include three elements. These are access to information, procedures for assessing the risk of illegal material, and procedures for mitigating any risk that is identified in the risk assessment. We will go through the due diligence requirements in more detail later in the presentation. Finally, operators must maintain records of their supplies and respective due diligence activities for 5 years. The key obligations for traders relate to maintaining traceability of the products they are trading. Traders must be able to identify the organizations they are buying from and selling to, and they need to maintain this information for 5 years. Traders shall be prepared to provide competent authorities, which will be described in a moment, with information on request. Moving on to entities that are involved in maintaining and enforcing the regulation, the European Commission formulated the EU Timber Regulation, as well as the related implementing regulations, and it is responsible for maintaining the EUTR. It may amend it in the future if that is seen to be required. The European Commission is therefore also responsible for the overall implementation of the regulation through the member states. It monitors the EU member states to ensure that the regulation is effectively implemented in a uniform way across all countries. The Commission is also responsible for recognizing and controlling monitoring organizations, which we'll go over in a few slides' time. Moving down from the European Commission, next we have the individual EU member states. The primary obligation of the EU member states is to ensure that the EUTR is implemented within their jurisdiction. They are responsible for ensuring that the necessary legal measures exist so that the regulation can be fully applied. In line with this, each state must set rules for penalties on penalties for infringement of the regulation. The penalties that each member state sets are required to be effective, proportionate to the infringement, and dissuasive. Each member state must also designate at least one competent authority to be responsible for the application of the regulation. I will speak about the obligations of competent authorities on the next slide. Finally, each member state must report to the European Commission on the application of the EUTR in their jurisdiction every 2 years. Moving on to competent authorities. These are governmental bodies who are responsible for the application and enforcement of the regulation in their respective countries. In ensuring the EUTR is applied and enforced, competent authorities have 3 obligations. Competent authorities must carry out checks on monitoring organizations at regular intervals and when in possession of relevant information to ensure they fulfill their own obligations. They should also monitor that operators effectively fulfill their own obligations. For this, competent authorities need to carry out checks that may include the premises of operators and field audits. Competent authorities can require operators to take remedial actions where necessary. Finally, competent authorities should keep records of the checks and the relevant information should be made publicly available. A list of competent authorities can be found at the link provided on the slide. The final actors are monitoring organizations. These are organizations that assist operators to comply with the EU Timber Regulation. According to the EUTR, monitoring organizations have 3 obligations. They must maintain and regularly evaluate a due diligence system and grant operators the right to use it. Should operators choose to use the due diligence system of a monitoring organization, monitoring organizations have the obligation to verify that it is being used properly. Finally, if it is shown that operators do not properly use its due diligence system, a monitoring organization must take appropriate action, which includes notifying the competent authorities in the event of significant or repeated failure by the operator. Monitoring organizations must be officially recognized by the European Commission, and their work is periodically checked by competent authorities in the EU member states. Their recognition may be withdrawn if they do not exercise their functions in accordance with the law. A list of recognized monitoring organizations is accessible using the link on the right-hand side of the slide. In discussing monitoring organizations and their due diligence systems, it's important to note that operators don't have to use a due diligence system developed by a monitoring organization. They may also set up their own. Given that the focus of the EUTR is on the prohibition of illegal timber and therefore requires the trade of legal timber, it is important that we understand what is meant by legal and illegal. For the definition of both legally and illegally harvested timber, the EU Timber Regulation uses the applicable legislation in the country of harvest. This applies to all countries, regardless of whether the country of harvest is in the European Union or not. Of course, legally harvested timber is that which has been harvested in accordance with applicable legislation, and illegally harvested timber is that which has been harvested in contravention of the applicable legislation. Given that different countries have different laws, the precise definition of legal or illegal timber in different countries will differ. However, the EUTR makes it clear which types of laws shall apply in all countries. These are those that relate to the legal right to harvest, taxes and fees linked to harvesting, timber harvesting laws, including directly related environmental and forest legislation, laws that encompass the tenure and use rights of third parties, and trade and customs laws. In defining legal and illegal timber, the role of international conventions is also important. While the national legislation of the country of harvest applies in the legality definition, so too are all relevant international conventions to which the country of harvest is party to. This is made explicit in the regulation. In full, the EUTR states that in the absence of an internationally agreed definition, the legislation of the country where the timber was harvested, including regulations as well as the implementation in that country of relevant international conventions to which that country is party, should be the basis for defining what constitutes illegal logging. Moving on, we will now look at the product scope to see which products the regulation applies to. Basically, the EUTR applies to virtually any product containing paper, cardboard, wood fiber, or wood, with some exceptions like bamboo products and printed publications. The EUTR document itself contains an annex on the last 2 pages which lists all of the product types it applies to. Products are identified using EU customs codes. So for example, 4403 wood in the rough, 4412 plywood, and pulp and paper products contained in chapters 47 and 48 of the classification are included. It is important to note that the regulation can be amended so the product list that the EUTR applies to now may change in the future. We will now look at the different types of products in more detail. Here we've listed the product types that are covered by the EU Timber Regulation. As you can see, there is a wide range all the way from raw products such as wood in the rough or fuel wood, through sawn wood and other solid products such as veneer sheets, plywood, and particle and strand board, to pulp and paper products. A number of what might be referred to as manufactured products are also included, like packing cases and boxes, casks and barrels, wooden furniture, and prefabricated buildings. There are a few exceptions, such as bamboo products and printed publications, for example, newspapers or magazines, and we'll look at these on the next slide. A number of products that are made of wood are not covered under the regulation. Firstly, there are waste products, which are defined as timber products or components of timber products that have completed their life cycle and would have otherwise been disposed of as waste, but instead they've been recycled and reused. An example of this is furniture made from timber recovered from the demolition of houses. This exception does not apply to byproducts from a manufacturing process. This includes wood chips and sawdust as a byproduct of sawmilling. These products are not considered to have completed their life cycle. Secondly, while furniture is largely included under the regulation, what are termed seats are not. Products made from plaited or woven bamboo are also not included, and neither are pulp and paper products made from bamboo. Packaging and printing material are also not included. When discussing different products that are and aren't included in the EU timber regulation, there are a number of specific distinctions that need to be made. For example, on the previous slide it was stated that printed materials are not covered by the regulation. This is true when the printing itself is the essential product, which is the case for books, brochures, or photos. A person buying a book to read is buying it for the printed words, and not for the paper itself. Some other products may contain printing but are covered by the regulation, such as facial tissue, toilet paper, and stationery paper. These may contain some form of printing, but the essential product is the paper or cardboard. With respect to furniture, as before, the majority of wooden furniture is covered by the regulation. However, seats, surgical, dental, or veterinary furniture is not covered. Furniture made from woven or plaited bamboo is also not covered. On the topic of bamboo, products made from solid bamboo are included, and this includes furniture and other products such as flooring. However, like I said before, pulp and paper products or seats made from bamboo are also not included. Finally, packaging sold as a product, or that which gives the product its essential character, for example decorative gift boxes, is covered by the regulation. On the other hand, packaging used to support, protect, or carry another product, for example in the transport or specific packaging for long-term use, like musical instrument cases, these products are not covered by the regulation. Moving on now to the enforcement of the regulation, we already established that EU member states set penalties for non-compliance and nominate competent authorities for checking compliance. The penalties are set at the national level, so will therefore vary between the different countries. However, the sanctions must be effective and proportionate to the severity of the violation and work to deter organizations from breaking the law. Sanctions or penalties can include fines, confiscations of products, suspensions of trade permits, and even imprisonment. Fines may be imposed on organizations with different roles in complying with the regulation. Fines may be imposed on operators if they place illegally harvested timber or timber products on the market or fail to exercise due diligence before placing products on the market. Fines may be imposed on traders if they cannot identify the operators or traders who have supplied them with the timber or the traders to which they have sold timber. Fines may also be imposed on monitoring organizations if they fail to maintain and regularly evaluate a due diligence system, and if they fail to verify the proper use of their due diligence system by operators and take appropriate action if an operator doesn't use the due diligence system properly. In terms of liability, it is the operator who holds liability or is legally responsible for maintaining an effective due diligence system to only purchase timber with a negligible risk of being illegal. Liability does not change when an operator employs the services of a monitoring organization to conduct due diligence. The operator keeps all of its obligations, responsibilities, and liabilities under the regulation. To establish non-compliance with the EUTR, there must be proof, and the burden of proof rests with the authorities. It is up to the competent authority, at times in combination with the police, to prove that the requirements of the regulation are violated. Now that I've gone through most of the general information about the EUTR, we'll look at the obligations of operators in more detail. Remember that operators are the companies that place timber products on the EU market for the first time, and that the key obligation is that they conduct due diligence on the products that they source to minimize the risk of the products being illegal. The EUTR states that the systems to conduct due diligence shall include procedures for accessing information on the products, conducting a risk assessment, and mitigating risk identified in a risk assessment. Operators may develop their own due diligence system or use an existing system provided by an approved monitoring organization. The purpose of the due diligence system is to manage the risk of placing illegal timber on the market. Information gathered is used to conduct an assessment of the risk of illegal timber, and if the risk is assessed to be negligible, it is okay to place the relevant material on the market. If the risk is assessed to not be negligible, the risk that is identified must be mitigated. Only once the risk mitigation measures are seen to have been successful in mitigating the risk to a negligible level may the product be placed on the market. The first step of the due diligence process is obtaining access to information. The information needed relates to the timber or timber products being sourced and the legality of those products. Specifically, information is needed on the species, supplier, quantity, and origin of the timber contained in the products. Furthermore, documents that indicate the legality of the timber are needed. With respect to species, the common name of all species is needed, and the scientific name as well, where applicable. The scientific name may be needed where the common name may be used to refer to more than one species. Information on the supplier of the material means the name and address of the organization that sold the material to the operator. The quantity of the product shall be expressed in volume, weight, or number of units as relevant for the particular material. With respect to origin, this means the country of harvest, but where applicable, a more specific region, or possibly even the concession of harvest, may be needed. This is the case when risk relating to the origin of the material varies within a country or region. Importantly, this information gathering stage does begin the due diligence process, but it's something that is returned to throughout the whole process. What is very important and really needs to be stressed is that while information must be collected, it is not enough to simply collect information and do nothing else. Collecting information is not a self-standing requirement. Information must be collected, but then it must be analyzed as part of a risk assessment of the legality of the material that it applies to. The aim of the risk assessment is to evaluate the risk of illegally harvested timber being placed on the market. The risk assessment that must be conducted relates to the origin of the material, the supply chain, and the species of the product. Within this, the specific criteria for risk needs to include the assurance of compliance with applicable legislation, which may include certification or other third-party verified schemes which cover compliance with applicable legislation, the prevalence of illegal harvesting of specific tree species, the prevalence of illegal harvesting or practices in the country of harvest and/or subnational region where the timber was harvested, including consideration of the prevalence of armed conflict. Also needing to be considered are sanctions imposed by the UN Security Council or the Council of the European Union on timber imports or exports. Finally, The complexity of the supply chain of the timber and timber products needs to be considered. The risk assessment needs to come to a conclusion, which, as we saw previously, determines whether or not additional risk mitigation actions need to be implemented before timber can be sourced and placed on the market. The conclusion must be that the risk of placing illegal timber on the market is negligible or non-negligible. If risks are identified that cannot be classified as negligible, the operator shall carry out risk mitigation. It is the responsibility of the operator to make the risk conclusion. If they engage the service of a monitoring organization, the monitoring organization is expected to verify that the conclusion is acceptable. In terms of how to define negligible risk, there is no definitive threshold that can be used. The level of risk can only be assessed on a case-by-case basis, as it depends on a number of factors. It is the operator that must define its own threshold based on an assessment of its supply chains and considerations of all risk assessment criteria. If the risk of placing illegal timber on the market is not negligible, measures must be taken to mitigate the risk that has been identified. Risk mitigation procedures consist of a set of measures and procedures that are adequate and proportionate to effectively minimize risk. There are no specific requirements for what risk mitigation measures must be, but they may include requiring additional information or documents from suppliers, requesting material that has undergone third-party verification, or replacing suppliers. One of the risk mitigation possibilities just mentioned was sourcing material that is certified as responsible or sustainable or verified legal through a particular voluntary certification scheme. Doing this can certainly play an important part in mitigating risk, but it must be noted that sourcing certified or verified material is not automatic proof of legality. As mentioned previously, only material with a valid FLEGT license or CITES certificate or permit automatically comply with the EUTR. What the EU has done is listed requirements for certification or other third-party verification systems that must be met in order to use them as part of the risk assessment and/or mitigation process. These are contained in a specific implementing regulation for the EU timber regulation. The criteria laid out by the EU, which in essence outlines the EU's definition of a credible certification scheme, are that the scheme must have established and made available for third-party use a publicly available system of requirements, which shall at the least include all relevant requirements of the applicable legislation. It shall specify appropriate checks, including field visits, are made by a third party at regular intervals no longer than 12 months to verify that the applicable legislation is complied with. Include means, verified by a third party, to trace timber harvested in accordance with applicable legislation and timber products derived from such timber at any point in the supply chain before such timber or timber products are placed on the market. And finally, include controls verified by a third party to ensure that timber or timber products of unknown origin or timber products which have not been harvested in accordance with applicable legislation do not enter the supply chain. The final topic of this presentation is the impact on the timber sector of producer countries that are supplying timber products to operators in the European Union. Firstly, it must be acknowledged that while the EU timber regulation applies to entities within the EU, the requirements for operators may be pushed down the supply chain to suppliers. By this, we mean that the requirements for information about the products and for evidence of their origin and legality, which apply to operators, will in turn be required by operators of their suppliers. Operators are likely to require a variety of information and documents from their suppliers, with the ultimate aim of being able to demonstrate compliance with relevant legislation. Information and documents are likely to cover evidence of origin, species, and supply chains of the material, with documents to verify legality aspects such as harvest, trade, and transport. Operators may also require their suppliers' operations to be audited, either by the operator or a third party. They may also request their suppliers to become certified and source and supply certified products. There are various issues associated with such requests. One in particular is that many suppliers may be unwilling to provide information on the supply chain that they are sourcing products from. This is because many suppliers will consider this sensitive business information that they need to keep to themselves to avoid increased competition when sourcing products. Continuing on, for a number of reasons, it may be that operators decide to source different products or source from different suppliers. This may be because they are unable to obtain the information they want from a particular supplier, or they may judge a particular type of product or supply chain too complex and too risky to source from. Finally, an impact on producer countries is likely to be that suppliers become confused and find it difficult to know what is required from them due to the EUTR. The source of confusion may be based on an unclear understanding of what the EU timber regulation requires. Suppliers may find it hard to understand what is required to satisfy the regulation because they get different requests of information from different operators. This in turn may be because different operators have varying levels of information already, or because their due diligence systems have differences. It could also simply be because not all operators themselves understand the requirements of the EUTR. With this slide, we list the official documents of the EUTR. Aside to the main law, the EUTR is complemented by two other pieces of legislation that offer more detail on specific points within the law. There is a delegated regulation which provides rules for the recognition and withdrawal of recognition of monitoring organizations. There is also an implementing regulation, which is a regulation to ensure uniform implementation of the law in different EU member states. Finally, we've listed a guidance document provided by the EU, which provides additional information on some aspects of the regulation. Bringing this presentation to a close, I'd like to thank you for watching. I hope it has been interesting and useful to you.